Well, in the state of Nebraska versus Anthony J. Garcia, the three-judge panel has convened, and we have written an order which I'm going to read into the record. Problem number 1 is the case history. This matter came on for trial on September 26th of 2016 on the amended information filed by the state of Nebraska, charging the defendant, Anthony J. Garcia, with murder in the first degree, a Class 1 felony of Thomas Hunter, on or about the 13th day of March 2008. Count 2, use of a deadly weapon, not a gun, to commit a felony, a Class 3 felony. Count 3, murder in the first degree, a Class 1 felony of Shirley Sherman, on or about the 13th day of March 2008. Count 4, use of a deadly weapon, not a gun, to commit a felony, a Class 3 felony. Count 5, murder in the first degree, a Class 1 felony of Mary Brumbeck, on or about the 12th day of May 2013. Count 6, use of a deadly weapon, not a firearm, to commit a felony, a Class 2 felony. Count 7, murder in the first degree, a Class 1 felony of Roger Brumbeck, on or about the 12th day of May 2013. Count 8, use of a deadly weapon, a firearm, to commit a felony, being a Class 1C felony. And count 9, attempted burglary, being a Class 4 felony. The defendant entered not guilty pleas to all of the above referenced charges. After the close of all the evidence and argument of counsel, and being instructed by the court on the law pertaining to this case, the jury commenced deliberations. On October 26, 2016, the jury returned verdicts of guilty on all 9 counts contained in the amended information. Based on the state of Nebraska's request that this court impose the death penalty as a sentence in each of the 4 murders at counts 1, 3, 5, and 7 above, the jury was instructed to determine which of the alleged aggravating circumstances, if any, existed in the commission of each of these crimes. On October 28th of 2016, the jury commenced deliberation to consider the aggravating circumstances related to the 4 convictions of murder in the first degree. The jury found the aggravating circumstances applicable in the murder of Shirley Sherman were: 1, the murder was especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. And 2, at the time of the murder, the defendant also committed another murder. The jury found the aggravating circumstances applicable in the murder of Thomas Hunter were: the murders were especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. And 2, that at the time of the murder, the defendant also committed another murder. The jury found the aggravating circumstances applicable in the murder of Mary Brumbeck were: 1, the murder of Mary Brumbeck was committed in an effort to conceal the commission of a crime or to conceal the identity of the perpetrator of such crime. 2, the murder of Mary Brumbeck was especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. And 3, at the time of the murder of Mary Brumbeck was committed, the offender also committed another murder. The jury found the aggravating circumstances applicable in the murder of Roger Brumbeck were: 1, the murder of Roger Brumbeck was committed in an effort to conceal the commission of a crime or to conceal the identity of the perpetrator of such crime. 2, the murder of Roger Brumbeck was especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. 3, at the time of the murder of Roger Brumbeck was committed, the offender also committed another murder. The jury determined those aggravating circumstances existed beyond a reasonable doubt in each of the above murders. On October 31st of 2016, Chief Justice Michael Heavican, pursuant to Nebraska Revised Statute 292521, subsection 1A, named a 3-judge sentencing panel to conduct a sentence determination hearing. The Honorable Gary Randall, District Judge of the 4th Judicial District in Nebraska, was appointed the presiding judge. The Honorable Rick A. Schreiner, District Court Judge in the 1st District of Nebraska, and the Honorable W. Russell Bowie from the District Court of the 4th Judicial District of Nebraska were appointed to serve as the 2 additional panel members for determination of sentence pursuant to statute. The court ordered a pre-sentence investigation pursuant to Nebraska Revised Statute 222261 and scheduled a sentencing determination hearing for March 30th of 2018. The hearing was subsequently continued to June 13th of 2018. The sentencing determination proceeding was held June 13th, 14th, and 15th of 2018 pursuant to Nebraska Revised Statute 2925, subsection 3. All three of the panel members were in attendance. Representing the state of Nebraska was Donald Klein, Douglas County Attorney, Brenda Beadle, Chief Deputy Douglas County Attorney, and Sean Lynch, Deputy County Attorney. The defendant appeared with counsel Jeffrey Pickens, Todd Lancaster, and Sarah Newell with the Commission of Public Advocacy. The sentencing determination hearing procedure for the three-judge panel is codified in Nebraska Revised Statute 292521, subsection 3. Accordingly, the three-judge panel is to take evidence the presiding judge deems relevant to mitigation, including but not limited to the mitigating circumstances set forth in Section 292523 and B, sentence excessiveness or disproportionality as provided in subdivision 3 of Nebraska Revised Statute 292522. The state alleged three aggravating circumstances in each of the four murders. 1, the murder was committed in an effort to conceal the commission of a crime or to conceal the identity of the perpetrator of such crime. 2, the murder was especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. And 3, that at the time of the murder of one of the victims was committed, the offender also committed another murder. The jury found two aggravating factors in each of the murders of Thomas Hunter and Shirley Sherman. 1, that each of the murders was especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. And 2, that at the time of the murder of Thomas Hunter and Shirley Sherman was committed, the offender also committed another murder. The jury found three aggravating factors in each of the murders of Roger Brumbeck and Mary Brumbeck. 1, the murder was committed in an effort to conceal the commission of a crime or to conceal the identity of the perpetrator of such crime. 2, the murder was especially heinous, atrocious, cruel, or manifested exceptional depravity by the ordinary standards of morality and intelligence. And 3, that at the time the murder was committed, the offender also committed another murder. The panel considered the above referenced aggravating circumstances as they related to the specific murders. Evidence was presented through expert testimony at the sentencing determination hearing, and exhibits were marked, offered, and received. After presentation of all of the evidence, counsel presented argument and was allowed to submit sentencing memorandums that were received and reviewed by the panel. Section 2, evidence considered by the panel. In making the panel's decision, the evidence adduced in support of the defendant's guilt and the evidence adduced at the sentence determination hearing must be considered, Nebraska Revised Statute 292521, subsection 3. Prior to the sentencing hearing, the panel has reviewed the evidence adduced at the defendant's trial and the evidence adduced at the sentence determination hearing, as well as the briefs of counsel and the pre-sentence investigation. Section 3, sentencing determination. The panel must consider A, aggravating circumstances, B, statutory mitigating circumstances, 3, C, non-statutory mitigating circumstances, D, proportionality. Those factors are considered in the order below. The panel notes that in assessing the weight to be given to the aggravating factors and mitigating factors, the panel does not use a numerical process, but applies reason and judgment per State v. Moore, 210 Nebraska 457. Subsection A, aggravating circumstances. The aggravating circumstances must be proven beyond a reasonable doubt. In the information, the state alleges three aggravating factors in the murder of Thomas Hunter. The jury found two of those aggravating factors applied beyond a reasonable doubt, as referenced above. In the information, the state alleged three aggravating factors in the murder of Shirley Sherman. The jury found two of those aggravating factors applied beyond a reasonable doubt, as referenced above. In the information, the state alleged three aggravating factors in the murder of Mary Brumbeck. The jury found all three of those aggravating factors applied beyond a reasonable doubt, as referenced above. In the information, the state alleged three aggravating factors in the murder of Roger Brumbeck. The jury found all three of those aggravating factors applied beyond a reasonable doubt, as referenced above. The panel has limited the review of the aggravating factors to the 10 aggravating factors found by the jury in the four murders. Accordingly, the panel finds that 10 aggravating circumstances alleged by the state of the four murders have been proven beyond a reasonable doubt. The panel finds that those aggravating circumstances are defined by law and are sufficient to support the death penalty. B, statutory mitigating circumstances. Mitigating circumstances are set forth in Nebraska Revised Statute 292523, subsection 2, and are viewed by the panel based upon the evidence presented at the sentencing determination proceeding and the finding of guilt. Further, the panel considered the pre-sentence investigation that it prepared in the case. State versus Bjorklund allows that. The state requested that the trial court agreed that the pre-sentence investigation report could be used to establish any statutory or non-statutory mitigating factor, but not aggravating factors. The state was allowed to present evidence that is probative of the non-existence of statutory or non-statutory mitigating circumstances, but chose not to do so. The defendant also was allowed to present evidence that is probative to the existence of the statutory or non-statutory mitigating circumstances. The statutory mitigating factors and findings of the panel are as follows. 1, the defendant had no significant history of prior criminal activity. The panel finds evidence that this mitigating circumstance. 2, the defendant acted under unusual pressure or influences or under the domination of another person. The panel does not find any evidence of this mitigating circumstance. 3, the crime was committed while the offender was under the influence of extreme mental or emotional disturbance. The panel does not find evidence of this mitigating circumstance. 4, the age of the defendant at the time of the crime. At the time of the commission of the murders of Thomas Hunter and Shirley Sherman, the defendant was 35 years of age. At the time of the commission of the murders of Roger and Mary Brumbeck, the defendant was 40 years of age. The panel has considered the evidence of the defendant's age, but does not find that the defendant's age to be a mitigating circumstances in the case. 5, the offender was an accomplice in the crime committed by another person, and his or her participation is relatively minor. The panel does not find any evidence of this mitigating circumstance. 6, the victim was a participant in the defendant's conduct or consented to this act. The panel does not find any evidence of this circumstance. 7, at the time of the crime, the capacity of the defendant to appreciate the wrongfulness of his or her conduct or to conform his conduct to the requirements of the law was impaired as a result of mental illness, mental defect, or intoxication. While the panel does find evidence that the defendant is an alcoholic and was using alcohol on a regular basis during this period of time covering the commission of these 4 murders, and the defendant has sought mental health treatment during the same period of time, these factors did not impair the capacity of the defendant to appreciate the wrongfulness of his conduct in the commission of these murders, and as a result, the panel does not find this to be a mitigating circumstance. In sum, the panel finds the only mitigating circumstance defined by Nebraska Revised Statute 292523, subsection 2, that exists is that Anthony Garcia has no significant history of prior criminal activity prior to the commission of the murders of Thomas Hunter and Shirley Sherman. C, non-statutory circumstances. Over the course of time, the Nebraska Supreme Court has also considered a number of non-statutory mitigating factors. In State v. Moore, the Nebraska Supreme Court specifically declared that the defendant could offer on the issue of mitigation any evidence, even though the mitigating factor offered was not specifically listed in the statute. See, for example, State v. Sandoval, bad childhood resulting from being raised by a dysfunctional family. State versus Vela, disadvantaged upbringing, borderline intellectual functioning, and being a follower of a charismatic leader. State versus Hochstein, emotional and intellectual immaturity and history of being easily influenced or led. State versus Reeves, nonviolent nature, passive person, out of character, and lack of memory in the time of the crime. State versus Ote, upbringing and psychiatric history. State versus Victor, conduct during prior incarcerations. The Nebraska Supreme Court has stated that the Constitution does not require a sentencing judge or judges to make specific written findings with regard to non-statutory mitigating factors. However, for completeness, the panel notes that the consideration of the non-statutory mitigating factors outlined in the cases set forth above, as well as the other factors and circumstances that one might argue mitigate in favor of the defendant. There is evidence the defendant sought psychiatric and psychological treatment and at times was prescribed medication as part of that treatment. In the panel's view, the defendant's psychiatric and psychological history does not rise to the level of mitigating circumstance to the actions taken by the defendant in commission of the murders of Thomas Hunter, Shirley Sherman, Mary Brumback, or Roger Brumback. These murders are separated by 5 years, during which time the defendant worked full-time as a physician, supported himself, and purchased a home and demonstrated he was capable of being a law-abiding citizen. I'm sorry, there's something wrong. I am, it's not nervous, it's pain. I apologize, but I have to take a break for a second.